Amid the ongoing celebration of America 250, people are sure to talk about how great the United States of America is and how it's the best and most successful experiment of self-governance and individual liberty in the world. But just this week, we've seen significant questions raised about a variety of rights, from the right of free speech on college campuses, to the right to keep and bear arms tied up in the courts, to even the right to not being searched or surveilled without a warrant. So, what should people understand about the creation of the Bill of Rights, and are those core rights withstanding the pressure of time? I recently talked with a professor about the first 10 amendments to the U.S. Constitution and what kinds of threats there may be to those rights 250 years in. To review the history of the constitutional civil liberties we enjoy, let's talk with Hillsdale Associate Professor of Government, Richard Samuelson. Professor Samuelson, thanks again for taking time with us here on The States. Before we talk about the first 10 amendments to the U.S. Constitution, which didn't come around until more than a decade after the Declaration of Independence. Unbelievable to think about that, but help us understand the difference between inalienable rights and those that are granted by government.
Well, thanks for having me on. It's an honor and a pleasure. Well, rights you have, the Declaration speaks of, right, you're endowed by your Creator with certain inalienable rights. And it says among these are life, liberty, and pursuit of happiness. That means there are more, it's only among them, and they're inalienable because you have them, because you're endowed by them, with them by your Creator. They don't exist because government created them. Government exists to protect the rights you have because you're human. So that would be an inalienable right. Of course, then when you actually have to apply them and be protected by government, things can get a little naughty. How far does it go? In what cases? It can be very complicated actually to protect your rights, right? Because government, sometimes they come into conflict. But it is the other kind of rights we often talk is right from the government. You have the right to be granted X, Y, or Z, and those are not inalienable.
You know, those are more considered kind of privileges, right? I mean, you have the privilege of driving on roadways and things along those lines. But obviously all of that is evolved over time. But let's get back to when the Bill of Rights came about. The Constitution wasn't enough to get people on board to sign it, right? What exactly is the Bill of Rights?
When the Constitutional Convention sent the Constitution to the people to be ratified, and they had special conventions in each state to ratify it, the main criticism was that there was no Bill of Rights. States had been drafting new constitutions, and they had often had Declaration of Rights. And people thought that was a rather large gap. Now, people like Hamilton and James Wilson, I believe, and Madison early on said, you know what, the thing is the Constitution is a Bill of Rights because it exists to protect the rights you have from your Creator. However, the people said, no, we want to have them written down. The criticism was, once you have a list, lawyers will get to it and say only those things that are written down. And so there was some concern there. Madison prudently said, well, if we write them the right way, so we're careful not to avoid that problem, he switched completely. He says, we will help get mass approval of the Constitution. So you go from not more than 50% maybe in many places of approval of the Constitution to overwhelming support for the Constitution. Say, we made a good faith effort to listen to the main criticism, which is lack of Bill of Rights. So that was added to the Constitution and approved by the people in the amendment process in 1791.
Now, how much of what the Declaration was there for, right? In 1776, years before the Constitution finally being ratified, how much of what they were dealing with before the Declaration added to the creation of those 10 core principal rights?
Well, many of those rights were rights that people had had in one way or another under the government of Britain and under their colonial governments, though they might be understood a little differently, interestingly. Consider the First Amendment, the freedom of speech and press. In England, that was a legal term. Those were legal terms, but they meant no prior restraint. That is, freedom of press, you could publish whatever you want, but you then could be prosecuted for seditious libel. Seditious libel means criticizing the government, bringing it into ill repute. In a world of sinners, that is very dangerous, right? For the government not to be respected. hence the logic of prosecution for seditious libel. We debated whether that was our standard, and we decided in the 1790s that was not our standard. You have the general right to criticize the government. That would make us a much more democratic republic.
And those various principles, again, you can see how they were dealing with, for instance, individuals' personal space being searched without a warrant, and even the idea of, I think, what is it, Amendment 3 is no quartering. Yeah. We don't deal with that in modern day, but who knows, down the line, it could be an issue that's brought up. But Professor, 250 years later here, how has technology put pressure on all of these fundamental rights?
Well, it's very interesting because when is a warrant necessary, right? So many things now can be searched on the internet. Previously, you need a warrant to go into someone's files. You go to their house or their office. Nowadays, the files, in a sense, they pass through a public airwave, in a sense. Does that mean they're no longer private? So you're getting some very interesting questions that modern technology presents. The other element, which I say perhaps as a teacher, is we are a less literate society. So the verbal element of it and the reasoning element of it, that you're protecting our right to discuss in public what the government's doing. And there's perhaps less concern with that among people who are spending less time reading and thinking about what government is for.
Yeah, and I think this issue of technology and, as you mentioned, the ability to have a warrant searching through information, but you also got to consider email. Email wasn't around 250 years ago, and surely that's got some protections from warrantless search and even other free speech issues and Second Amendment issues. All of these things being debated at state houses across the country and even in courts. We'll talk a little bit about the interpretation of these rights when they do get into the court system, into the third branch of government, the judiciary. But let's talk a little bit more about the pressures on these core rights, these civil liberties, these inalienable rights. How have natural disasters or even national emergencies like COVID or 9/11 or world wars or a variety of other things out of our control, how do those impact our civil liberties?
Well, emergencies often are causes of problems for liberties, right? We have infamous for prosecuting people for sedition in World War I, among other times, right? And in COVID, there was a lot of people being shut up under pressure by government. The government wanted to pretend they were not involved. They tried to work through third parties, but it seems to me that's what they were doing, and that's deeply problematic from the perspective of civil liberty. And that is much easier when your conversations take place in a public forum that can be electronically shut down. If these are in pubs or restaurants or your local Elks Lodge, it's much harder for the government to monitor them all than when it's in a public forum that can be monitored and shut down electronically. So that's one element of it. The other thing to keep in mind is America's record on this, compared to other countries, might not be that bad. That is, it is always the case that in emergencies, civil liberties are in jeopardy. And when you compare America's record in that our excesses are not as great as the excesses of many other countries. Now, maybe that's not the most happy standard to use, but it's not entirely unreasonable.
Professor, obviously, whenever a state does something that somebody alleges violates their rights, it gets filed in the courts. And then you've got the tier of courts system from the district to the appellate all the way up to the U.S. Supreme Court and a variety of different interpretations on how these rights are applied. But talk a little bit about the ideas of being an originalist Supreme Court justice or even a judge in the district or in the appeals level. The difference between an originalist versus those who are not considered originalists.
Well, it's a very interesting question. There is a living constitution, which means it evolves over time. But when you press someone who says they believe in living constitution, and you say, well, what is allowed? In what direction may it live and may it not live? You say, how do you know what would be out of bounds? They wouldn't want tyranny, of course, but what is that? An originalist, now there are camps of originalists. One is a very strict textualist who said, well, we didn't deal with the kind of problems. We didn't have telephones, ergo, it's not a problem that we can address from the originalist perspective. Seems to me it's more reasonable to look at how they reasoned about the problem of privacy. And because they understood technology changes, and it applies to new circumstances, you have to apply the same kind of circumstance, right? So your privacy and your private conversation is what was protected, and that what's a private conversation, two people on the phone, is not public, right? And just like your mail was not public. So that would be the kind of thing, and then you apply it to new standards, where some people want to just be very narrow and literal. I think that's rather too much. The critics of originalism say, oh, that's living Constitution. I don't think that's true, as long as you have the same understanding of liberty and the same principles that you're using to reason through the problem.
Well, Professor, to wrap things up, I guess let's get to the tough question here of what to expect in the future. If you could get out your crystal ball and share with us what kind of future threats are there to the civil liberties that we hold dear?
Well, interesting. It's very tough because one of the main threats to civil liberty are civil rights laws. That is your general right to associate. The government decides who can be in the room, and part of who can be in the room is who do I have to exclude today? And for good reason, after Jim Crow, we had to suspend that. But if that becomes your first move, is the government tells you who can be in the room, you've lost a significant part of your right to privacy, and the same would apply with speech. You don't want to keep saying, well, I think such and such a group is bad at work. You drive some out of work. But you can have a discussion, as people do, about whatever is a current political problem, right? If you could discuss, say, COVID, are the vaccines working or not, right? That would be a discussion. The government wants to crack down on it, but it's the spirit of the government going into your daily life and saying you can't do that because it's bad for business, so to speak. And I think civil rights was, in a sense, one of the things that started that, because there was a very legitimate case where the government had to go into civil society and say, you guys are abusing each other and we got to stop it.
It's something definitely to remain vigilant over, and something worth continuing that conversation. Hillsdale Associate Professor of Government, Richard Samuelson, thank you so much for your insights and joining us again here on The States.